Hello and welcome to the podcast. I'm Karen Weaver. We talk a lot about data in this day and age, and data, as I define it, is the new oil. Everybody wants to strike it and take advantage of it and leverage it to make money. That has become a common refrain when talking about how to generate new revenue streams in college athletics. Monetizing your fan base, your donors, and others who may not yet know about the opportunities to engage with your athletic department requires gathering data, lots and lots of data. But how do we do that ethically and within the framework of existing laws? My guest today is the perfect person to talk about this emerging space. Kristy Gale is the CEO of Honor Data Rights Management. Her company provides data rights management solutions, particularly for health, biometric, and performance data, to stakeholders to promote regulatory compliance so they can monetize their data and comply with evolving regulations governing use of their data. Kristy, welcome to the podcast and welcome back.
Thank you so much, Dr. Weaver. Thanks for inviting me. I love talking with you and I love your podcast. So thank you. It's such a pleasure to be here with you.
This is such a great topic. The timing of it. One of the things I want to start off right away because it's one of the reasons I followed up with you. We have all these NIL contracts coming out, and a lot of them talk about the players' data rights. Can you walk us through why presidents need to understand that?
Sure, that's a great place to start. First of all, having this new contract structure with the athletes is a completely new way of operating and doing business. It's something that we're not exactly used to. So there are a lot of things to get your arms around just in the contract space. When it comes to terms related to athlete data, you need people who understand the issues involved. And so you need to understand the regulatory landscape, the laws that pertain in your state specifically, and then federal laws around data privacy, but also intellectual property, including the NIL statutes. And now we're having there are some states that have biometric data privacy laws. So that is impactful. But where AI is increasingly utilized in the data collection and analytics, that's something to be aware of, and how you can contract with your data partners. There are just so many issues to consider, but when it comes to the contracts with the athletes specifically, this is really a new topic. There aren't contracts yet that are incorporating, substantial terms around athlete data in them. And each university does things a little bit differently as far as their data collection partners, the data they collect internally, and how that data is used, who they send that data to. NCAA, for example, just announced in the last couple months that they are authorizing championship data, so March Madness game data, for example, to
Yes.
be sent to Genius Sports. And then that data can be pushed out for sports betting. And so, as you can imagine, if universities and athletic conferences and the NCAA and Genius have access to that data, then of course, athlete performance data will make its way into those product offerings as well, whether it's for betting or fantasy sports or other uses that we can talk about later in this conversation. But it's not robust right now. The short answer is contracts for athletes and their data rights is not robust. We're not seeing a lot of terms. The reasons for that is not many people know about it. They don't understand the risks involved. They don't understand the ownership and control challenges that are involved. And then the athletes themselves and their agents typically aren't educated about this. That's one of our big focuses right now is really just education for all of the stakeholders because it is a new paradigm. So I can talk more about the contract terms specifically, but really we're not seeing many. So there's a big educational push around that.
Yeah, that's why I wanted to have this conversation now because everybody's talking about the contracts and how to break the contracts or who's responsible to hold whom to account. But these contracts contain life-changing commitments on behalf of the athlete. And you brought up the Genius Sports, which I'm glad you did. The fact that they bought this data of the NCAA championships, how could an athlete possibly opt out? They might not even know that their personal data is being collected during the first round of the NCAA tournament, the second round, and so they may not be given a document signed saying, yes, I grant permission to do this.
Yeah, I love that perspective. That's one of the big concerns. One of the major problems when anytime there's consent involved. In the law, they call it scope creep. And that's where you may have required and requested and received athlete consent to collect data one time for one purpose, but that expands. And so right now, the main practice is in large athletic departments and programs, they will talk with the students, say twice a year, the athletes, and say, we are collecting your data in these ways for these purposes. And those administrators usually rely on FERPA, that federal act
Interesting.
that governs student privacy. But that's really insufficient for the age that we are in now with the Internet of Things, wearable technology, computer vision and deep learning, AI, all of these new type of Internet of Things capabilities, machine learning. That data collection and use certainly isn't consistent over time, and FERPA certainly did not contemplate this broad and deep data collection and then use, not just for the athletes to perform better and the team to perform better, but for monetization. So yes, the athletes probably really have no idea and the Notre Dame study that we did partnering with them did reveal that the athletes typically understood to some extent data was being collected from them. They weren't clear on the extent, how much data, what all it was being collected for, who had access to it. That's a whole other issue of access. And even when universities or programs try to limit access, there's still quite a few people that have access, and that privacy hygiene or password hygiene and other cybersecurity, other types of hygiene around performance data is not robust as well. And so the athletes typically, one, don't have a good idea of all the data collected on them. Two, don't know who's seeing it. Three, assume that the university controls and owns it, which may not necessarily be the case. It varies by contract with your data collection provider. And then also the athletes assume that the program will do what's in the best interest of the athletes. But the reality is as much as they have aligned interests, there are some interests that are not aligned. And so the athletes need independent review, whether that's an attorney, agent, players association, whatever that looks like.
Yeah. Yeah. So that's interesting because let's say it's a football team of about 105 guys, and one or two decide they want to opt out of this. How do you do that when they're on the field playing in the game? How do they not collect that data? I'm just wondering how a school might be able to mitigate some of these problems.
That's a great question. I mean, initially, it has to go back to those partnerships and the contracts that you have with your partners. But being an attorney, I know your contracts, as soon as the contract signatures are done, you already have other ways that you want to engage with each other. Right. And so those future engagements are not always completely contemplated in the written agreement. And that's especially true in this situation. You want to go back and look at those contracts that you have with your providers. Most universities have a partnership with either Catapult, for example, or Whoop, and you can see what type of data is collected and when and for what purpose. And you might need to amend those. I don't want this to be a plug for what we do, but we're trying to automate all that with our technology. We automate that so that regardless of what's in your contracts, your business practices, you can do that compliance function in real time. And you can also do the business, those contracts with the athletes and the university in real time as your use for that data changes and as the collection means change. Technologically right now, I don't think it's possible to separate the data collection for those students who opt out. And in fact, I don't really hear of those student athletes that are opting out. And one of my colleagues who I just really appreciate her scholarship and her athlete first focus, Alicia Jessup, a professor at Pepperdine University, had an article come out in the last year about this issue with athlete consent and how some of their Fourth Amendment rights may be violated. And one reason for that is they don't really have an opportunity to opt out. If you're in a meeting once a semester with your athletic department staff, your coaching and training staff, and they're saying, we're collecting this data, and just know, and that's essentially your notice and your consent and your waiver for anything else, but you really aren't advised on all of the data collected, who sees it, and what it's used for. So you can't make an educated decision. Alicia Jessup, her assertion is, well, then how can it really be consent?
Yeah.
Essentially, these athletes aren't really fully aware of the decision that they're making And so there could be violations of legal rights there. And we very much are aligned with that. So as an administrator, you need to understand, one, this performance data is in a gray area legally, not necessarily covered by FERPA, not necessarily covered by the privacy rights of your state and the NIL laws. Sometimes they're not completely aligned. So the best thing is to get educated, whether that's through your attorneys or it's really in the college sports space, you kind of have a whole new team of advisors at this
Yeah.
point, and make sure you're getting the right advisors to get this information right from the get-go so that you're not opening yourself up to litigation, primarily class action lawsuits or regulatory intervention, although I understand there's some desire for regulatory intervention in college sports right now, but really this is something that you don't need regulatory intervention for. It's something that you can take control of today and maybe even start incorporating provisions around your athlete data in your existing privacy programs, because everybody has a secure, cybersecurity and privacy programs.
I think that's such an important point, and I'm glad you made it because so many times presidents and others just throw up their hands and say, well, what are we supposed to do? Well, you can sit down and start with education, right? With the athletes. What are you signing? What does it give up? What are your rights to take it back? That type of thing. I don't know that anybody, most people that I would come across would be objecting to that. It's just whose responsibility in the athletic department is to do that and make sure that the athlete has an open dialogue to ask questions about it. Let me give you an example. About 8 months ago, I saw a contract, NIL contract, that basically said the athlete keeps their NIL rights while they have eligibility. But then once their eligibility is up, then the NIL rights go back to the institution because they want to use it for Hall of Fame material or documentaries about the program, that type of thing. And they don't want to chase these athletes down. What do you think about that?
I think it's a fair carve out from the university perspective, but it's overly broad. So sorry, I'm putting on my attorney hat right now.
Yeah,
No legal advice given, but my perspective is there's a better way to write that contract that allows the university to utilize some of those rights into perpetuity, but it's not exclusive. That the athlete also would have ownership, that they can also license that out to others that they want to license it to along the way. So that others, for example, if the athlete goes pro, the pro organization doesn't have to come back to the university to get licensure and approvals to use that footage in a ESPN 30 for 30 at some point. Or, to me, it's like you have to look with the end in mind and that type of contract. While completely understandable, the perspective of the university, you have to think from a business perspective of how feasible is that? And does a university have a clearinghouse or a clearance center on site that can clear those things? Probably, I know they have legal teams, but that's just a whole new level of trying to manage that. And bad deals today are bad deals tomorrow. Someone's going to have to administer all of that in the future. So you want to think about that.
absolutely. So you mentioned your Notre Dame study. Let's talk a little bit about that and what you learned.
Thanks. Yeah, we're really pleased with the results. We were able to reach out to and partner with athletic departments from top 75 D1 universities. Most of those were top 30 universities, and gain a better understanding of how they're collecting and using athlete data today, and also how those programs want to use that data. I also talked with athletes to see what they know about this and what they would want done with the data, how they could use the data. And really, the broad strokes of that research found that, of course, the top universities are utilizing athlete management systems and collecting all different types of data. And even in talking with one sports performance leader in college sports, I made a comment of, oh, so you're collecting all of this subjective data. And he corrected me and he said, there is no subjective data. Things that I thought were personality type, how the student or how the athlete performs in school with their grades, and other things that I wouldn't have thought would directly correlate in performance, athletic performance. But these departments are tracking all of that. And to their credit, they are trying to do it in the most compliant way possible, limiting who has access to that data, anonymizing the data where possible. But really, these days, the value is knowing who that data pertains to. So it's limited, right, in how you can really anonymize that data, but still utilize it effectively. And with these athlete management systems, they can then draw on all that data, the coaching and training staff, and create more personalized training regimens and dietary guidelines and sleep patterns, everything for these athletes to become elite and perform even better. And of course, that translates well for the university and the teams as a revenue generator, being a winning university. But the athletes, they're really fueling that and providing that data, yet they don't always know what's collected on them. We also found that there's a much higher percentage of males who understand data being collected on them and have an understanding that perhaps they could utilize their own data to monetize. They could include it in their content, their posts, their NIL deals, their partnerships to enhance the storytelling. Whoop, for example, um, this is not connected to a university specifically, but Whoop in general, when they partner with athletes, whether that's Patrick Mahomes in the NFL or Sha'Carri Richardson, Olympic runner, they indicate that that data tells a story about the athlete and how they perform day to day and whether they need rest or what type of training they need. And so, for example, in Europe, some of that player data, not this granular biometric, biomechanical data. That's not being used quite yet, but geo-tracking and placement on the field and where a ball goes from point A to point B. In soccer or global football, that's being used in augmented reality overlays in game broadcasts so that you're almost getting kind of a video game feel to the broadcast. And they're finding that that's really engaging Gen Z and Gen Alpha in the content. They want to be immersed in an experience, and in sports, it kind of gives it that video game feel. And so certainly athlete data can be utilized in that way in the future. And so the male athletes have a better understanding of maybe monetizing their data. Female athletes don't. And then also historically, female athlete data has not been collected for as long or to the extent that male data has been. So there's a gap there that needs to be filled, especially in this great age of advancing women's sport and having more revenue generated there, more fans engaged there. So there's some discrepancies there. But overall found that university programs in general are definitely leveraging athlete data collection, the analytics related to it, helping the athletes perform better. And they also have an interest in monetizing that data. Before I go further, that was a lot. Any other follow-up questions before I share a little more?
Yeah, that's fine. I did want to mention last year during the World Series, I saw what you're talking about, the augmented reality. They had the two teams on YouTube playing each other, and they were hitting the ball, the hits, everything was the same as the game. It was just augmented reality. I really thought Major League Baseball was going to make a push into that. And they may have, for the very reasons you mentioned, Gen Z's interest and attention span. But there is something there to that. And it strikes me that athletes should have some control over whether that's being used with their name, image, and likeness. Do you agree?
I agree, especially, really the laws are the publicity rights laws and NIL laws. They're kind of the same or similar. It gives an individual the right to receive compensation for their name, image, and likeness. And data is included in a right of publicity or name, image, likeness in that it one personally identifies a specific individual through, for example, their biometrics. There are laws in the US that state biometrics can be considered a publicity right, which is what NIL is. And so anything that an athlete creates or provides, including their data, is a property right. So aside from the privacy issues, which is a separate concern, property issues. And so under the law, the athletes are providing the data, they create the data, it's initiated by them, it's something personal to them, it identifies them specifically. So under the law, the athletes own that data. Now, the teams and leagues in college sports, there's not leagues, but there's athletic conferences, and their data partners are utilizing athlete data, not necessarily as a publicity right. I think it's something that they really need to take a look at because there is some risk there. There's some liability there because the athletes really do own the data. And then when the universities and their data collection partners come in, they create contracts that determines who owns the data. And in some cases, it's the university, and in some, it's the data collector. But regardless of that, the laws indicate that that data that the athletes provide is it belongs to the athletes. And again, it's a gray area. So that's where we come in and we want to help people with that. But I certainly agree that the athletes they do own their data. They need to control it. They need to be educated about it. And to your point, Dr. Weaver, when you mentioned that maybe the coaching and training staff need to give more information to the athletes so they can make that decision regarding whether they want to authorize the use of their data or not. That staff needs to be better educated.
Yeah.
Athletic department staff is already, in my opinion, humble opinion, one staff member might be wearing 5 hats, frankly, 5 hats, and to
No
add one
question.
more,
No question. Yeah.
whose role is that and how do they get educated and add that to their long list of things that they're trying to do? So that's a consideration too of like making it a goal, determining who's going to provide that role and making sure they're educated and they can give the athletes the right information.
And not that this is the subject of this podcast, but I'm noticing more and more states are allowing high school athletes to monetize their NIL. And I'm wondering if they have any clue as to what they might be giving up in some of these contract arrangements. I mean, it feels like the wild, wild west. This is what we talk about all the time, but it really feels like we've aim, shoot, and then focus, I mean, that type of thing. And I really hope presidents can understand the risks that are involved. Yes, I know they see the revenues, and we're going to talk about how to generate revenues in a second. But the risks that are involved if you have 1,000 athletes in your department, you have 1,000 different issues, just for one particular plan. Any thoughts on that?
Yeah, so it really is, I know you have departments that can look at this, but it's making sure that your security and privacy is including athlete data specifically and how you're going to treat it. So I come from most recently fintech, financial services and technology and fraud prevention. And a data breach or sharing data that's not authorized is the cardinal sin.
Yeah.
Because there's a reputational loss, there's a revenue loss, and a relationship loss with your customers. And frankly, university administrators are looking at those same factors, that if there is athlete data shared without consent or authorization or used in ways that weren't contemplated by the athletes or even university staff, the athletic department staff, and it goes beyond scope, you suffer reputational loss because it's going to be in the news. You will have to do damage control. You have relationship loss a relationship gap between those athletes and certainly fans and alumni that will need to be repaired. And then from a revenue perspective, of course, you're going to have to put a cost. There are dollars attached to compliance. You cannot comply or you can comply, and you comply and there are fees associated with that. And I heard a rule of thumb recently that it's double. Your literal monetary cost could be double at least for non-compliance versus if you comply. And so it's really just, again, getting educated about these topics, starting small and incorporating terms around managing the privacy and property rights for the athletes and the university and your other partners. Start implementing some initial terms in your existing policies and programs, and then you can build from there as this continues to evolve. But don't wait until later. Don't wait until there's litigation, or don't wait until there's an ugly mess you have to clean up and it's a PR issue.
There's so many people looking for this these days too. I mean, because it's happened. We think about the data breaches in the government and other places, and people get angry when their data is shared illegally and they want someone to fix it. Imagine how you would feel with your university if all of a sudden your athletes' data was all at risk for some reason.
Well, I love you bring that up because usually when people think of privacy, it's consumer data. So using my example in financial services, the worst, the 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 data that I would have access to would be someone's social security number, their physical address, a phone number, and their banking practices. That's nothing compared to knowing someone's heart rate, their propensity for a genetic disease or propensity for injury or access to their sexual activity. I was talking with someone recently that shared that this is in a D1 university program, that someone on their staff realized the female athletes were utilizing technology that would show their activity 20 And there was an athlete that whose heart rate would spike in the middle of the night. And so then that training person wanted to have a conversation with the athlete about that. And then there was a big conversation about that's kind of outside our purview or our scope, because you can imagine what was happening in the middle of the night if there's a heart rate spike, and who should really know about that? Whose business is that? And same with what substances are in an athlete's body. And yes, there needs to be balance. There needs to be ethics and bioethics in place. But the reality is, too, that could be an issue for a university, a reputational issue for a university, if you're finding that you're collecting and that your coaching and training staff have more information than is needed to help an athlete train better. There's obviously an argument that there is some relevancy to have that information, but you need to have those conversations
Yeah.
before it's a bigger problem. And it also leads to the reality that athletes are the ones who they're providing the data, but they're also those who are the first to suffer some downside risk
Yeah.
decreased privacy in some of those other things that are, decreased playtime, like I mentioned, or shortened career life cycle, or less money, based on what their data is saying about them. On the other hand, I just learned of a pro athlete that was able to negotiate a much higher contract because of his performance, and he actually asked his trainer to provide his data to his agent to utilize in those contract value conversations, and he got a higher contract value. But again, it's to me, I'm concerned, like, who all saw that data and,
Yeah.
control
Yeah.
it, control it. So, yeah, those are the things that have to be considered.
Wow. That's a lot to think about right there, but it's coming, and we have to accept that it's here, and that we have some coaches who are more tech savvy than others, but we have to have some sort of guardrails so the athletes have control over this. So, if we're looking at the landscape, and I know presidents are always looking for new revenues, right? And data monetization, as I said in the open, data is the new oil. How can universities think about leveraging data ethically, but also to generate revenue?
That's the key question, right? And I think it takes a little bit of unlearning. Some things we're used to thinking in college sports, the revenue generators are tickets and broadcast rights. And it's realizing, yes, that's true. And we need to expand it beyond that. We even need to expand it beyond, it's not expand beyond renaming your facilities, because you can only do that every so often, right? You can only raise ticket prices and tuition and fees. And, we're trying to find sustainable revenue streams right now. So you have to be a little bit forward thinking and not rely on what you knew in the past. So that's the first thing I would encourage is be open to new ideas. And then two, be open to not just new partners, but your existing partners, restructuring those deals. I know a lot of universities have partnerships with data distribution companies, and those data distribution companies are intended to help generate more revenue for the university, but the university is paying a cost for those services. And I think it's good for universities to think about, I can drive revenue, I can generate revenue, I can provide a product. And with athlete data, that's really what it is it's a product from the athletes licensed essentially to the universities and athletic conferences, who they in turn can then license it to all of these other parties to generate revenue. And so the nice thing about athlete data is if you do it right and you manage all of these compliance functions, some of which we've talked about, if you do it right, then you have a commodity that is cleared to use as revenue, and you can utilize it every year, right? Every year at least, maybe every semester, you have a new source of that athlete data. So it's not going to run out or go away. You always have a new source of athlete data. And if you're one of those top programs that are really leveraging NIL, then you have a new moneymaker. So it's thinking about, like we've talked about, you can maybe utilize that data in augmented reality broadcast overlays with certain broadcasters. Maybe your current broadcast partners can utilize that technology. It's happening. But maybe you want to have new over the top, like streaming services or other what we've seen in pro sports, other broadcast partners who can utilize this data. Think about new products, whether that's internally in your athletic program, athletic department, how you want to engage fans and tell stories, or if you want to partner with other content creators or Netflix docuseries that can kind of bring a lot of attention to some of those non revenue generating sports that we're so concerned about. Maybe you have a great story to tell, and that athlete, one, you can market that story there. I can tell you, I've been talking with people who want those stories and they're looking to create content for these types of products for people like me who would love, I love docuseries or documentaries, and learning about people. And thinking about too, honestly, in video games. Right now, video game makers are going to the athletes and saying, "We'll give you $1,500 to let us use your NIL for this video game this year." Well, in the pro sports space, the way that's handled is you go to the Players Association, they collectively bargain for those rights for the athletes get a cut, the association get a cut. And in the college sports business model, the universities would get a cut. And
Yeah.
ideally, the athletic conferences and anybody involved. It's structuring these deals in a wise way where everybody wins. So you can take that data and plug it into video games. And yes, the game makers or those content creators would have to pay more, but that's fair market, right? That's fair market. You're getting something. You're getting, frankly, they need to look, and that's what we help with this emerging data market. Look at the value and what it's worth and be thoughtful about it and think again with the end in mind. If I want all of these athletes to be in my video game, think about what that deal should look like and who should be involved in it. Because the athletes from their, or I'm sorry, the universities from their perspective, I would say this is my commodity. And I've shared with you already how I feel about athletes. For me, they're first priority. So I don't want to turn them into a commodity. But
Yeah.
when you're looking at revenue, that is a resource that universities have in spades. So it's like, okay, how do we utilize the information we're already collecting from these athletes, partner with them, they get some cut from it, they get a cut. We have a brand new revenue stream that, you don't have to go big and say we want millions of dollars, but you start with doing a fair market value and analysis and determine what should this what should this deal look like? Who should be getting paid from it? And you can do that with mobile apps, with video games, with augmented reality overlays in broadcast, with fantasy sports and sports betting. And as much as there's still angst with college sports and sports betting, the reality is there is lawful betting on college sports. So why not draw revenue from that rather and not just draw revenue as we'll send some in-game data or championship data, but we'll determine what the appropriate data sets are to share that won't decrease competitive advantage, that won't disclose too much private information, but still allow there to be a market for those who want it, the fantasy sports players or the sports bettors who want an edge, some type of subscription service for them to utilize that athlete data, and then the university gets dollars from it.
Gotcha. Gotcha. Wow. Kristy, you've given us an amazing amount of information to think about. And I know, having talked with you other times before, you're just at the tip of the iceberg. But I really do appreciate your thoughtfulness and helping presidents, trustees, other campus leaders understand how complex this topic is. This is not just about points scored or minutes in a game. This is a whole different world that we're talking about. So I really want to thank you for coming back on the podcast and sharing with my audience this insight.
You're welcome. And thank you, Dr. Weaver. Thank you. It's always a pleasure to be with you. Thanks.
Likewise.